Alrighty, people. This We the People News. Okay. Um, this is gonna be part 4, right? And I just want to say this, y'all. Jury notification for the people. Rights for the people, not for the kings. Alright? Jury notification is rights for the people and not for the kings. Just want to say.
1970s Supreme Court decision, I think, and you point out in your book that the general attitude of the Supreme Court to jury authority of this sort has sort of risen and fallen over time. One of the big developments in jury rights in the last year or so has been that the Supreme Court made a dramatic, I would say long overdue, reversal of a terrible decision from the 1970s, in which states had been permitted to allow juries to convict without unanimous agreement. So that ruling seems hopeful to me, but there have also been some decisions that have greatly upset me in recent years. Notably, for want of one more justice to agree to hear the case, the court had refused to review a case in which the accused had their sentence for a minor drug offense drastically enhanced because the judge felt he was guilty of a whole slew of these other more serious charges of which the jury had explicitly acquitted him. I think the term for this is sentencing on acquitted conduct. The court has also lost Justices Scalia and Ginsburg, who, at least to me, to my not particularly plugged-in, knowledgeable self, they struck me as both at least somewhat friendly to juries. So I'm just curious, do you have a general sense of the court as it is now composed? Is this likely to be good or bad for preserving or restoring trial by jury? Any sort of temperature check that you might want to share on that?
Sure, and I just want to make one other comment. So you were talking about kind of the unanimous jury being sort of approved of, which is terrific. That the Supreme Court came down that way, and unfortunately, it should have been, I think, a lot earlier than that. But one of the things that we still have remaining is that we have fewer than 12 people required, and that's significant. So essentially, you can have a 6-person jury convict someone when it should be a 12-person jury. And the United States Supreme Court has said yes to 6 people deciding as opposed to 12 people. Imagine that. Like historically, it was supposed to be 12 people. Again, 12 on the grand jury, 12 on the jury unanimously deciding, and instead we have only a requirement of 6. And so I wanted to also just point that out to people that we have another major problem, and the United States Supreme Court should revisit that question and should decide that it needs to be 12. Of course, we don't have any cases going to juries, so we have to solve the plea bargaining problem, probably more importantly. But in terms of your question, the jury generally, where we look at history and we actually sort of comply with history, that actually really helps in terms of jury authority. And so we have had various justices on the Supreme Court, such as Justice Scalia, who has been more tied to than many of the other justices. Right now on the court, we have Justice Gorsuch has some sort of tie and interest in the jury and has written certain sort of opinions that kind of, even when he was not on the Supreme Court, in favor of jury authority. With that said, I think there's always some hope on the criminal front in terms of jury authority. Right now, in terms of plea bargaining and getting to the plea bargaining, there's no hope because everyone seems to think that's an important part of the criminal justice system, and we need to get that turned on its head to have people like, for example, bail reform. That's been, people have been turning that on its head. Well, I think this needs to be turned on its head in terms of plea bargaining. But outside of plea bargaining, I think on the criminal front, there's more of a likelihood to tie things to history. So, for example, what you were talking about and using, factual determinations by juries to determine whether or not a sentence can be imposed. That's something that over time the court has been in favor of and has made decisions that support that. On the civil side, which we haven't talked much of, and maybe we'll touch on a little bit later, the court's not as interested in that, even though the civil jury is absolutely extremely important part of the Constitution. So I don't have much hope on the civil side at all. I have a little hope on the criminal side, but not with respect to the significant issue in that being plea bargaining.
Mm-hmm. Yeah, the only bright light I can kind of sort of see on the civil side is I know that Sonia Sotomayor was interviewed by New York University School of Law's Civil Jury Project, and she seemed pretty friendly to civil juries.
Yeah, I mean, there was an opinion where I think it was a case where she wanted the case to be taken on cert, and it was involving, I think, a police shooting of people who should not have been shot and who were innocent, kind of sort of people just because essentially of their race, it looked like that they were being targeted. And she talked about how there was a jury question in that case. So I think Justice Sotomayor may be someone who can kind of be a jury champion in some of these cases. But I think we have an uphill battle right now in the Supreme Court.
Yeah. I'm glad you brought up the issue of the number of jurors. That's not something we had talked about before this, but if you don't mind, I would love to ask a couple questions about that. So if I recall correctly, the stripping down of the jury size from 12 to 6 kind of goes back to that same 1970s Supreme Court that seemed to hate juries. I don't know if that's just through my filters, but they seem very, very, they touched on a lot of jury issues and were ruled very unfavorably. And I think one of them basically described the number 12 as an accident of history or something to that effect. And I'm wondering if you think that a challenge to that would be more likely either to criminal jury size or civil jury size, if that would be received more favorably by the current court, or if that's something I don't know. Where can we go with that? Are there possibilities there?
Yeah, I think that given the decision on unanimity, I think that given that there is some hope to looking at the 12-person jury. I think that the difference there is that they're going to be thinking about efficiency. They're going to be thinking about lack of resources, and as a result, it may be too early to make that challenge. But I certainly have more hope after the unanimity decision that that this might be something that could be challenged. But one other thing that I want to say in relationship to this is, all of you viewers, one of the things that you might want to kind of recognize is that over time, like if I have a graph or a figure in my book, and it shows how there are the Supreme Court that say yes to jury authority, and then 20 years later on the same issue they say no to jury authority. And that means that, and I'll give you an example. So in a civil case, after you win a jury trial, if you're a plaintiff and you win a jury trial, originally this was challenged and they wanted to sort of say, oh, a judge could overrule the jury. And the United States Supreme Court said no, a judge cannot overrule a jury. And then just 20 years later, the United States Supreme Court said, oh yes, a jury can decide and then a judge can overrule a jury. And this may sound outrageous to you, and it really is. I mean, it's so odd. But a judge will say, I don't think a reasonable jury could find for the plaintiff. And as a result, I'm going to say that I'm right. And the jury, which was picked by the two sides, we spent lots of time picking that jury, the jury's wrong. And as a result, the other side wins. And originally, again,
Yeah, so default that the 6 or 12 juries are dumber than the judge is what the judge is saying. Y'all are too stupid, so therefore I'm going to take over and I'm going to make a deal on this. Just saying. He's acting like a king and not a judge.
the Supreme Court said no, that's not constitutional, and then 20 years later said yes. So we have this history of over time, the United States Supreme Court saying no to jury authority over time after it already said yes, the jury has this authority. So essentially, there's been a grab from authority from other parts of government. All these other parts of government have more authority, and the jury has very little authority.
Yeah, I really am thinking how much the efficiency problem kind of comes into play even more now during the pandemic.
We're going back to what the kings are saying, that we are smarter than we the people, and we must give more authority to the government, so that way you little sheep will stay in your pens like where you belong.
Because something I've seen in more than one state is, oh, we have this huge backlog of people who are at least not yet ruling out their right to trial by jury. What are we going to do? Oh, let's cut the number of jurors on these trials from 12 to, I've seen, down to 8 or 6. I think 6 is the minimum currently allowed by the Supreme Court. So there it is, just basically eroding your rights for the sake of efficiency. And maybe you can give us an idea of why do we care if it's 12 instead of 8 or 6?
Well, to me, you need one. I do think history matters here. There's a reason why we established the trial by jury. It was literally people. If you look at historically, many of the founders say it was the most important right, and that right was 12 jurors convicting someone. Putting aside the civil jury for now, but convicting someone of a crime. Now you're saying 6 have to agree as opposed to 12. Well, that's a big difference.
Yeah, all of them have to be saying that, that it's beyond reasonable doubt that the jury's convicted you, especially if you have all 12 saying, yeah, well, there is enough reasonable doubt that you're innocent or enough reasonable doubt that you're guilty. Man, it just makes it so much easier for 6 and 8. What happens? The less people it is, the easier it is for somebody to comply with somebody else. That's the reason why they always have one person wanting to be the top dog in the jury, the king of the jury. Just saying. Oh, what? The rest of them is not allowed to think on their own? And there's always some type of government officials in that jury box. Didn't think about that, y'all.
And if I'm accused of a crime, I think we should stick with what we established and was a really great system that we thought was a great system. And I don't think that the United States Supreme Court itself will be able to change that system in favor of efficiency. So yeah, I think it's to get 12 people to decide versus to get 6 people to decide. It's a huge difference.
Yeah, and especially in terms of like jury nullification, having to convince 12 people instead of just 6 when there is a unanimity requirement, which there is now. that's definitely a huge game changer, and particularly in the last year, it's totally disheartening to me especially in light of your description of the Chinese jury system in the book, is the new law that was widely protested in Hong Kong. It seems like every day I see another news article about someone being arrested, they're not getting a jury trial. Special judges loyal to the Chinese government are now basically the ones deciding if political protesters, people protesting the government, will be convicted of major crimes like terrorism and incitement to secession. Are there any other countries that seem to you to have made notable shifts in the last few years, either in terms of degrading jury rights and protections, or perhaps, if you have any, toward improving them?
Didn't think about this, y'all, and I may be wrong or not. But why is family court so adamant of actually not having juries? Because it's getting more and more every day that CPS is involved themselves in family matters. People are been losing their kids in family courts. They don't want jury in there because there's been 50% divorce rates or more, and CPS is running rabid of kidnapping your kids. They cannot have juries in there because the most likelihood of people that is really irked at family courts all in a hole. This is the way the people news. Bye, y'all.